Hey guys, it is Tuesday, September 14th. So I'm here doing my usual live video for y'all. And today I thought I would talk about the difference between federal versus state criminal defense and some of the differences in both areas. Uh, One of you asked me a question or asked me to answer a question on this live, and I will. I'm not going to call you out by name because I'm not sure what you're attempting to do, but I'll hit that at the end. So, generally speaking, federal court and state court are just two completely different animals. Federal court is very formal, very structured, and has specific rules to be followed, and the calendar is established from the beginning. I'll go more into that in a minute. Another difference is that the charges are usually not fresh in federal court. And what I mean by that is, if it's a state court drug case and you get pulled over with drugs, the police will arrest you there, then and there, and take you and put you in jail, and you'll be assigned bond and you can bond out or whatever. Most federal drug cases are the result of months, sometimes years of investigation, collecting evidence before they decide to finally put an end to someone's criminal enterprise. Now, that's, most of the types of investigations that we're talking about this far from the border. Obviously, there are people that get caught at the checkpoint, sometimes with human cargo, sometimes with drugs, and the feds were not watching them, and it was just a lucky grab. But even in those situations, before that person is formally charged in federal court, there is an extensive investigation done. So I would say, close to 99% of the time when I take on a federal case, the entire case, meaning discovery, police report, everything is all already done. I'm not waiting for anything. That's in federal court. And once you are arrested in federal court, you are very quickly brought in front of a magistrate to determine, counsel status, meaning can you hire your own attorney? Are you asking for the public defender? Or in multi-defendant cases, are you asking for the CJA panel attorney to be appointed? So once the counsel determination is made, they will also very quickly set you for a detention hearing. And in federal court, that is your one shot at being released on bond, so to speak. Bond is also different in federal court in that it often does not involve money, just a signature. There will be a bond amount, let's say $20,000, and you have to sign a document saying that you understand that you're responsible for $20,000. And the reason the federal government does it that way is because if you decide to run, that federal judgment can haunt you forever, and they'll get their money if it comes to that. But honestly, not a lot of people run on federal cases. Anyway, so once you have had your detention hearing, and this is true whether or not you get bond or not, a trial schedule is set in your case with all the dates and deadlines given to you up front. Now, depending upon which federal court you're in, you may be able to get some continuances from that. There are some courts where you basically cannot, although I guess COVID has put a change on that. And, part of the reason for the quick schedule and the scheduling order is not just the Speedy Trial Act, but it's because, as I told you, in most of these cases, all the discovery's ready as soon as you're taken to court. So your attorney gets all the evidence against you immediately. In state court, if you get arrested, you'll get bond, and then you'll get an assigned court date. And it's not uncommon for us to go to the first court date and not have anything, not even a police report sometimes. It's not uncommon to wait months for videos. It's not uncommon to wait months and months for lab results, these types of things. That doesn't happen in federal court. It's all done before you ever get to court. So in state court, once your bond is set, or if you're in jail, at some point, if you're in jail in state court, at some point later, you can have a bond reduction hearing if your bond is too high. You can file a writ of habeas corpus seeking for bond reduction. Sometimes you can have more than one bite at the apple depending upon the judge that you're in front of, but it's much different than state court. You know, realistically now, especially with what we've had with COVID and the backlog of cases, you could end up in state court with cases being reset for a year before it ever gets put on a trial docket. There are some judges that like to move their docket and make you put it on the trial docket sooner than that. But with big trial dockets, it still just keeps getting reset because there are so many cases set for trial that you just don't get reached. The federal system moves much more efficiently than that. And again, part of that is because you're not having to seek resets for months and months waiting on evidence to come in. So, you know, for those of you that are familiar with state court, it's like I said, you can reset a case, and then eventually you'll have to go on the trial docket and get reached. But some of that time could be waiting for evidence. So, in addition to the big differences in cases, because, you know, if you get stopped with less than a gram, that's not going to be a federal case. They don't care about that. The feds want big cases involving lots of drugs. And so those investigations, you know, take much longer time. So oftentimes, most of the time in federal court, what we're dealing with are cases that are much more complex than a simple state case for possession of less than a gram. You know, federal cases, many times on the drug cases, it involves drugs coming from across the border and going to various points in the United States. And then the government tracks the money coming back from various points in the United States back across the border. And so there will be a lot of surveillance, a lot of wiretaps where they've listened to cell phone conversations, just a lot of evidence to go through in some of these federal cases. So they tend to be more complex than state cases. Federal court is also much more formal, and I guess sort of more like what you see on TV, because after you get your detention hearing, the very next step is to arraign you, meaning have you enter a formal plea of not guilty, and then that's when you're given your trial schedule after you've entered your plea of not guilty. But the courtroom is much more formal. So before the federal court starts, you'll be sitting in the courtroom, and all of a sudden at some point you'll hear a loud knock on a back door, usually 3 knocks. And there are some judges that I believe instruct their person knocking to make sure that they knock extremely loud. So when you hear that knock, that means the judge is coming through that door and everyone needs to stand up. The judge comes in, is announced, the judge will give everyone permission to be seated and then start calling cases. And everything in federal court is on the record. So if the judge calls a case, he will ask for counsel for each side to introduce themselves for the record, and starting with the government. So whoever the AUSA is handling the matter for the United States will state their name on the record, and then whoever the defense attorney is will speak after and say, my name's Mark Diaz and I'm here for Joe Smith. And then the proceedings will start. The judge dictates who talks, when they talk, that type of stuff. It's very formal, but it's also very nice. It's very professional. Most federal judges treat all parties very fairly and very respectfully. There's not usually a lot of fighting. When I say fighting, I mean, the verbal exchange between the government and the defense attorney, the way that we sometimes do in state court. And that's, probably because of the atmosphere, the need for professionalism, and you certainly don't want to get dressed down by a federal judge. So we all trying to maintain our decorum in the federal courtrooms to that end. Now, that's not to say that we act like idiots in state court. I just mean, we're in state court I'll give you a good example. In state court, in felony court, on any given day, pre-COVID, you could have 30 cases on a docket. Typically, in federal court, if you're given a time, and this varies a little bit from judge to judge, but some judges will set you at 9 and not call the next case till 9:30, then 10 o'clock. They're very, very structured. Some judges will put 2 or 3 cases at the same time slot and then decide which order to take the cases in, when the judge gets there and reads through what's on the docket for the day. But I've never had a case where, there's 30 people, 30 different defendants in a federal courtroom, there's a small exception. I'm involved in a federal case right now that involves now over 100 defendants. And very early on in that case, the judge required all attorneys and all defendants to be present in the courtroom. And that judge has a very large courtroom, so it wasn't crowded. But, that's the most I've ever seen in a federal courtroom. But again, that was because it's a case involving over 100 defendants. But generally speaking, when you have a time for federal court, you're going to get that time. As some of you know, in state court, your court may start at 8:30 and you might not get out of there till 10:30. That generally doesn't happen in federal court. I can't right now, just thinking off the top of my head, I can't really think of a time that I've ever waited more than about 30 minutes past the time, that was my docket time for my case. Of course, there have been cases where we'll have multiple defendants being sentenced at the same time. And so, maybe I'm not speaking for the entire 30 minutes, but it is my case. It's just not my defendant's turn yet. That's kind of a different situation, though. What I meant was, in state court, cases are being handled individually, and depending upon what's going on that day, you may have to listen to someone's bond hearing. You may have, any number of things can come up that keep you in state court for a couple of hours that morning, and that just really doesn't happen in federal court. I don't know, those are the simple differences. If anyone had a specific question, I could come up with more. I just now seeing comments. Okay, so I had someone text me actually and ask me if I could address something here on the live for them. And the question is, can you record someone without telling them and then use that in court? So for obvious reasons, I'm not going to say his name because I don't know what he's up to. But the simple answer is yes. In Texas, to record requires the consent of at least one of the parties, and you as the recorder give yourself consent to record, so that allows you to record someone without telling them that you're recording them. And your question was, can I record them in my house and then use that? I'm going to jump out on the limb here and say that's probably some type of family law litigation that I don't do, but the recording law is the recording law. So if you want to call me or text me again and ask me more specifically about your situation, if I can, I'll try to answer it for you. But generally speaking, yes, you can record someone without their permission, because only one party's permission is needed, and you as the recorder give yourself permission. Okay. Hey Juan, I see you on there, Mom and Barbara. Joshua, yes, I can certainly talk about Penal Code Section 2503 next week. That's about all the comments I see. Joshua, I'm going to make a note right now so I remember to either incorporate you into my discussion next week, or I'll do like today and just answer at the end and see if I can help you out with your question. That's about all I got for today. I hope y'all all have a good rest of your week. Thanks for watching.